So next up on our agenda is our legislative debrief. We're going to turn our attention to the Pink Dome with these three experts, and then we're going to continue that conversation later today with a panel of legislators. So please join me in welcoming our next set of panelists. Okay, so these guys hardly need an introduction to this crowd, but I will do a brief one anyway. Up with us today, we have Greg Ellis, who has a long history in groundwater, and with this organization, we have taken to referring to him as my great-grandfather, since he held this position a couple of generations back. Next to him is Ty Embrey, who is with the Lloyd Gosselink law firm, principal there. Familiar face down at the legislature, started his career there, and is a highly effective lawyer and lobbyist in that realm. And then Brian Sledge, SledgeLaw Group, also someone we get to see a lot of, which is always our pleasure. We see him at the Capitol, we see him at our meetings, and appreciate all of his efforts on behalf of so many Groundwater Conservation District clients. Also, all three of them began at the legislature working on Natural Resource Committee or any other committee, and bring a lot of experience to the conversations we're having today and pretty much every legislative session we have. So we are going to discuss the bills that passed, what didn't this last session. We're going to talk about what GCDs need to implement. And then we're going to look forward and close with a discussion on what we might see over the interim and what we might see return again next session. So I just wanted to start with some general observations. Greg, let's start with you. How would you characterize this session as a whole? Kind of what factors, players, themes were dominating the conversation?
Well, we keep hearing right now that next session is going to be a water session. I'm trying to figure out how that's going to be different than the last couple of sessions. There were quite a few bills filed. I think there weren't quite as many groundwater bills this time as there were the session before that, but there were a lot. And I expect that to continue because we're seeing where the various interests are coming into collision. I'll discuss a little while the bills dealing with retail public utilities and how there were bills filed diametrically opposed to each other on that issue. So the toughest part about this session, and I hope something we can change for next session, was it seemed like it was everybody versus the groundwater conservation districts. And it didn't matter which side we were always on the wrong side. We're up there trying to protect these water supplies for everybody, and we don't see a lot of help coming from the utilities, from agriculture, from the industry that utilizes these water supplies to come in and defend these rules that we all collaboratively came up with to try and protect the water supplies for everybody. If that doesn't change, I promise you the legislature is going to stop listening to groundwater conservation districts and simply listen to the people who are talking the loudest. So we need to make sure that it's not just the district that's up there testifying on these bills. We need the permittees who want those rules, who want those restrictions, those protections up there helping us out.
And then Ty, why don't we go to you? To what extent would you say that the bills filed this session actually kind of were consistent with the themes that we heard Greg talking about and the themes from the interim?
No, I definitely felt like the bills were very consistent with what the interim work that had occurred in the Senate and the House. You know, one of the things that has been very helpful, and a lot of people in this room are participating in, is the TWCA Groundwater Committee. And it's amazing, you know, when we have that initial first meeting of the Groundwater Committee, TWCA, you know, leading into a session, everybody, you know, you got any ideas? What issues you want to talk about? It's fascinating, all the different issues that come up. And then for that committee to vet it, it kind of eliminates a lot of elements of surprise, because if somebody's got an issue going on in their area, they bring it up at the TWCA Groundwater Committee, and we're able to vet it and work on it. So I feel like, and you know, the House Natural Resources Committee under Chairman Larson has been traveling the state for years, and we're very active last interim, before last session, traveling all over the state, dealing with it, having testimony on issues. And we've joked about it, but I do want to compliment Chairman Larson and Shannon Houston. The interim committee report they put together was pretty incredible. It was very comprehensive, very thorough, and it covered a lot of all the issues that they had studied during the interim. So between the work that the legislature's doing in the House and the Senate and the TWCA Groundwater Committee, there's not a whole lot of surprises. I think one surprise that came to mind when I thought about this question was Chairman Perry had Senate Bill 2027, which we're going to talk about later, which dealt with changing the standard of review when a groundwater district gets sued in at the courthouse. So that was one I didn't see coming, to be honest with you, and we'll be dealing with that during the interim, and we'll talk more later in the presentation.
Thank you. And then Brian, you were a co-chair of the Groundwater Committee at TWCA. I was hoping you might just share a little bit about how consensus groups worked this session and kind of their effectiveness, how they fit into the water conversation at the Capitol.
Sure. We didn't have our most effective session of all sessions, but I still thought they were effective. And just for a reminder for those who may have forgotten, we had a long stretch after Senate Bill 1 and Senate Bill 2 in 97 and 2001 where we just had these absolute free-for-alls at the Capitol on groundwater issues. Every session, it was absolute distrust, and everything was surprise. You didn't know you were going to be dealing with a particular topic until the bill got filed on 90% of the stuff. I mean, we'd sit back there. I see Steve Cosp at the back of the room. What is the San Antonio water system going to come at us with this year on the groundwater district side? Or C.J. Treadway, what's the Oil and Gas Association going to do? Of course, you're over there wondering, what are the groundwater districts going to come at us with? And it was just these absolute free-for-alls. And if you look at the batting average on those things, it was deplorable. I mean, you'd get literally maybe one bill passed and amended Chapter 36 in a session. It was just, and it was a crapshoot on whether you got, it was an all or nothing deal. There weren't many compromises in much of those pieces of legislation over about a 8-10 year spread there. So we did develop the consensus process. TWCA had its groundwater committee. We've been doing that for many sessions. TAG has led a big effort during the interim. And I think the effort we had this session was, and during the interim, was basically on par with what we've done before. We always start off saying we're only going to try to tackle 1 or 2 issues. We end up coming up with 10 issues. We get 7 or 8 consensus bills. There were a lot of white papers that TAG worked on this session. And we finally all get comfortable with them, and we get on a consensus basis. And we have to remember that just because we all finally agreed on something and everybody compromised a little bit doesn't mean that the legislature's all going to jump on it and embrace it. We get some of our bills that folks just won't file. Some of them that were on a topic we thought this member wanted us to address. He just doesn't like the way we did it, and he does his own thing. That's not unexpected. I still think the process is extremely valuable and so much better than it used to be before we started doing it for everybody involved.
Thank you. So I would just mention, I don't know, I had a PowerPoint for this panel, and I think it's probably karmically fair that it's not going to work for me of anybody, and I know these guys can wing it, but if we could get that pulled up, that would be fantastic. But we'll dive in anyway, PowerPoint or not. So we're going to now just turn to the bills that passed. I'm going to just ask each panelist to cover kind of one topic, and we're going to start off with Ty, House Bill 1066. Right. If you could speak to that one, please.
Right. Followed by Representative Forprice, who's a member of the House Natural Resources Committee. And this is just a continuation of an effort to, really make it really clear how the operating permits would work and their renewals and their how they would be extended, their terms would be extended. So House Bill 1066 would sync up, I should say, the export, for districts that have an operating permit and an export permit. This would link up the terms for the operating permit and the export permit. They would be in line. They would be renewed at the same time to avoid multiple public hearings on, basically the same water project or the same, water use, operating permit versus export. This syncs those two things up under Chapter 36.
Thank you.
One quick comment on that bill. The other thing that bill did is it ended, I think, forever the question as to whether or not that's supposed to be one permit or two permits. You can't sync up the export permit with the operating permit if they're not two separate permits.
Good point. And then actually, Greg, you're up next. I was going to ask you to talk about House Bill 722 and Senate Bill 1041, both dealing with brackish groundwater.
These are the brackish groundwater bills. Senate Bill 1041, all that really did was extend the deadline for TWDB to complete their studies of availability of brackish groundwater supplies across the state and finding what we're calling brackish groundwater production zones. Then House Bill 722 by Chairman Larson was the bill that created the methodology for issuing permits within those brackish groundwater production zones. First off, to be a brackish groundwater production zone, you have to determine that there's not going to be a significant impact on any fresh groundwater supplies, and it can't already be utilized by anybody else. So, I don't know, 90% of the state probably is off limits, mainly because of all the oil and gas production that's already producing that brackish groundwater. So the studies have resulted in just a few brackish groundwater production zones so far. They're going to continue to move across the state and hopefully find a lot more. The permitting deals with, first off, GCDs, groundwater conservation districts, are still in charge of issuing those permits, and they have to adopt rules to do so. The Water Development Board study determines the total production amount for each zone, but they must also determine the maximum production amount for the actual well field after an application is filed. There's a 30-year permit term on those brackish groundwater production permits, and the permits are authorized for municipal use and electric generation, but the rules may not prohibit production for other uses. So I'm not sure what that section means. I'm still trying to figure that out. I think this is going to provide adequate protection for the freshwater supply side and does a good job of creating enough of an incentive that people will actually go out and spend the money to produce and treat that brackish groundwater. I think we found a good balance. If we don't see that happening, I'm sure we'll be back to revisit this issue.
I'd be curious to see how many petitions for those rulemakings we see coming.
Well, I'm hoping the districts that over zones don't wait for petitions for rulemaking. I hope they move ahead with rulemaking now. It benefits all of us, for those who can afford it, to treat that brackish groundwater instead of turning to the cheaper freshwater supplies. So we need to do whatever we can to incentivize that.
And then the next pair of bills that we're going to talk about are the ASR and Managed Aquifer Recharge bills. I've asked Brian to talk about House Bill 720 and 721.
Absolutely. You know, I was just sitting here thinking, the first time I heard about 720, my wife, Shauna, and another water lawyer, Jason Hill, and I, like half the other rednecks in the state with bass boats during the middle of Hurricane Harvey, had gone into the Houston area to try to save people and pull them off roofs. And that's what we were up in the Spring Cypress area, out saving people, and you know, it's a hurricane. I mean, it's coming down out there. And I get this text from Chairman Larson, and it's something, I forgot what the number figure was, but it was like 12 trillion gallons of water are going to be lost to the Gulf of Mexico. We could have captured this and used it for the benefit of the people of Texas. I was like, God, he is, you know, that's a real water geek right there. That's what he thinks of, right? Who happens to also be the chairman. And I mean, we laughed at it at the time. It's House Bill 720. It's now law. If we could have captured those flood flows and ejected them and beneficially used them, and that's what it is. 720 and 721, mostly they're amendments to the surface water chapter of the Water Code, Chapter 11, to help expedite the process at TCQ for making amendments to surface water rights to allow ASR projects. As the bill unfolded during the legislative session, it also added a key second component, which was aquifer recharge projects. And that's just doing recharge projects to recharge the aquifer without the hope of recovering water from the bubble as a water supply in the future. And that was a key development. You know, we actually added an item to the list of beneficial uses of water in the Water Code for the first time since I've been doing this. Aquifer recharge is now an actual beneficial use. And so those are things that are going to be big rulemaking projects at the TCQ over the interim. It didn't do anything to change like what the water quality standards are for injecting water through a recharge project or an ASR project. It didn't do anything to really affect the relationship on jurisdictional lines between the TCQ and groundwater districts, but they're significant bills. And of course, 721 is the bill that requires the Water Development Board to do studies of ASR projects across the state. Now they're also doing studies of aquifer recharge project potentials across the state.
Thank you. And you hit on what I was going to actually ask you as a follow-up, in the sense that these bills, while they're relevant, they actually don't change the way that GCDs operate, because this is outside of their sphere. So I also wanted to touch on a few bills that are not exactly groundwater bills, but definitely affect groundwater districts. And I have asked Ty if you could just touch on HB 2840, dealing with some public meetings.
Right. This is something that it was an amendment. This bill amends the Open Meetings Act, and I think there was some frustration in some instances from members of the public that went to their legislator and they filed a bill and ultimately passed. There's some governmental entities that have put the public comment section of their agenda at the very end. So public would get up, the governmental entity would go all the way through their agenda, and then boom, it would be public comment time. Well, the public would say, wait, I wanted to talk about that agenda item. Y'all have already discussed it and voted on it, so I never got that chance. So there's a change to the Open Meetings Act that House Bill 2840 put in place that said that public must be given the opportunity to comment before or at the same time as an agenda item comes up on the agenda, if they so desire. So, a lot of entities that I work with, they've already had the public comment at the beginning of the meeting. That kind of solves that problem. But that's a change to the Open Meetings Act as a result of some governmental entity, conduct out there. And that's something that we all need to be mindful of as we're working on our agendas for the board meetings.
We don't want to make the public have to stay until 11 o'clock at night.
Yeah, and you can have a reasonable limit on the public comment, just like you've in the past. But you just gotta give people opportunity to speak when that agenda item is either before or when it comes up.
Right.
So.
Thank you. Another kind of government-related bill for GCDs to know about, two of them actually, regarding disclosure, House Bill 3001 and House Bill 1495. I've asked Brian to touch on.
Sure. I think a significant part of 3001 for most districts is that you have to report certain information to the comptroller's website annually that they post about all governmental entities in the state, local governments basically. And the gist of the changes to that this session is if you adequately post that same information on your website, the comptroller can just, instead of having to provide that information to the comptroller every year, they can just choose to put a link on their site to your site if you're providing that same type of information. 1495 and also Senate Bill 65, which is kind of the same thing, were part of a big movement this session against taxpayer-funded lobbying. And don't let it escape you that this was the big session that they were pushing for tax reform, and the leadership did not like the fact that while they were trying to rein in the taxes of local governments, whether that were city, counties, school districts, water districts, that those same entities could be paying lobbyists with those tax dollars to fight their efforts to lower the tax collections, because that's generally what it was. And so it went from tax-paying entities. There are a lot of folks in the room that aren't tax-based. They're fee-based. Some of the versions of the bills had fee-based elements. Those bills didn't actually pass, but there were a couple of amendments at the end of the legislative session, and 1495 was one of them. And the bottom line on that is you just have to be transparent on dollars that you spend at the Capitol lobbying. And for most folks in this room, I think it's true that you don't actually hire a lobbyist. You have legal counsel or you have something like that, and there's these convoluted bills that most legislators don't understand on the intricacies of groundwater management law, and we have to go up there and be in stakeholder groups, and you end up spending enough money on legal fees that it crosses the barrier that your lawyer now has to register as a lobbyist. I mean, that is the typical pattern we see. It's not like you wanted a lobbyist. The legislature made your lawyer become a lobbyist. But you're just going to have to, under these bills, you're going to have to put in your budget what you're spending on those, how many dollars you're spending on those efforts, how much you budgeted for it, how much you actually spent, and that's pretty much the gist of what passed.
Thank you. And then kind of going back to overarching themes of the session, I did ask Greg to touch on for us what finally happened as it relates to groundwater districts with Senate Bill 2. If you want to make it, thank you.
Well, this was the crowning achievement of this legislature, this and House Bill 2, which dealt with public education financing. Senate Bill 2 is an attempt to try and limit how much local property taxes can go up each year. I'm suspecting this fall we're going to see some of the biggest increases we've ever seen in preparation for not being able to increase it again the year after that. It applies to all taxing units. The good news, and the only thing I'm talking about here, because I don't want to get into the convoluted formulas for the major taxing entities, I think every groundwater conservation district in the state, with maybe one exception, has a tax rate less than 2.5 cents per $100 valuation. That makes them, by definition, a small taxing unit or a special taxing unit, according to the new verbiage in the tax code. And those special taxing units keep the current rollback rate of 8%. So if your total new revenue is 8% higher than last year's no new revenue rate, or goes over that level, then you're going to have an election to ratify that increase. Under the current law, the voters can put together a petition to force an election. The petition is no longer necessary. Instead, if you go over that 8% mark, then there's automatically, you have to conduct and hold an election. So if you go over 8%, make sure you go over by enough to pay for the election you're going to have to hold for going over 8%. I think that's again, the other taxing units have some pretty convoluted formulas they have to follow. There's something called I forgot what the phrase they use is, the de minimis tax rate. That deals with if you can set a tax rate that will raise $500,000, even if that takes you over either the 2.5 or 3.5%, depending on what type of taxing unit you are. I don't think any of that's going to apply to any of the groundwater conservation districts. If there's any district out there that's charging more than 2.5 cents per $100 valuation, then those rules would apply to that district.
Thank you, Greg. And then this session, I think a lot of the very interesting bills fell in the what did not pass category. And we're going to walk through these. I'm laughing because I'm looking at my notes, and I actually have in here to have these gentlemen say in a sentence what it would have done, why it did not pass, and should we expect it to come back around. My thinking is that would be a very long run-on sentence.
Yes.
So I'm not going to ask you to keep it to a sentence. We've got maybe about 2 minutes per topic here on these bullets, okay?
Well,
so we'll start with Ty on Senate Bill 1010.
Yeah, I'll try to keep it under 2 minutes. So Senate Bill 1010, as a lot of people in this room know, was filed by Chairman Perry, and it was to try to create a situation where districts need to have, required to have similar rules with the other districts that are over a common aquifer and within the same GMA. And if they have rules that are different, then they need to be able to explain the reasons why. I think it comes down to, the differences of opinion come down to really two things. Major things. One, where would that explanation and where would the exercise and where would the explanation of the differences occur in the GMA area or in your management plan? The legislation had it in the management plan. I think a lot of groundwater districts would like to have that exercise done in the GMA. That's been such a successful process for groundwater districts over the last decade plus. And then the production rules. Do you compare production rules or do you compare all of your rules? So I think there was just a difference of opinion on that. And so those are some of the things that were brought up in public testimony at the legislative committee's hearings on the bill. And do I think it'll come back? Yeah, I think we'll see it again in some form. And it'll be the third session we'll work on this issue.
And then, Greg, could you touch on Senate Bill 2027, which Ty previewed for us a bit ago?
I think this was the biggest surprise of the session. I guess if you were following conservative newsletters, and especially on a nationwide basis, you might not have been surprised by this. And I think this is actually being pushed by the governor's office, this whole idea that we should change the standard of review when you're appealing a decision of an administrative body. The only administrative bodies targeted this session were groundwater conservation districts. Under the current law, if a district makes a decision and that gets appealed to a trial court, there's not a whole new trial. It's under substantial evidence review, meaning if there was substantial evidence to support the decision made by the district, then the court has to uphold that. We actually had a lawsuit over that, and I got a good opinion out of the Third Court of Appeals. De novo is Latin for to brand new. In that case, if there's an appeal, it goes to the district court, and the district court starts the entire process over from day one. All the evidence has to be reintroduced at trial. All the witnesses have to be brought. I'm not sure if it's going to be in front of a judge or jury. I think you could probably do a jury demand on that. So the decision of the district at that point is absolutely meaningless. So if that were to pass, then the Groundwater Conservation District Board would make all the decisions except those that matter. And this, again, is part of a nationwide effort. People are going after federal agencies thinking that this ought to be de novo. They want this, the Texas Public Policy Foundation is pushing that this be done on a statewide basis. The people testifying in favor of this were Fort Stockton Holdings Company out of the Middle Pecos District, the Farm Bureau, and the Texas and Southwest Cattle Raisers. So there's some powerful people that are behind this effort. It'll be interesting to see what happens during the interim. But Senator Perry announced at the hearing that the bill is being postponed to June, so we didn't have to worry about it this last session. But he also announced that it's going to come up during the interim, so expect this to be discussed this interim.
And you made an interesting point about if that were something, I mean, if these questions were to go to a jury, to have a jury of 12 citizens making these highly technical, sophisticated decisions on permit applications is pretty astounding. That would be a huge shift. So, okay, Brian, you are up on attorney's fees.
I think you're going to have to limit us to one sentence. Historically, the proposal was for the Attorney General to represent groundwater districts when they got sued, just like all state agencies get represented by the Attorney General. Because of the fiscal note on that bill, it was decided by the legislature that instead districts, if they won in a lawsuit, would get their attorney's fees, and that was a one-way deal. Only districts could get their attorney's fees. There have been numerous proposals since then who forgot how it came about and said, this is unfair. If you're a permit applicant or somebody suing the district, you ought to get your attorney's fees, even though folks don't typically get attorney's fees from governmental entities. These bills, 2125 was a consensus bill through the TWCA process that still had it be a one-way deal for groundwater districts, but it was just permissive for the judge to award them instead of mandatory if the districts did. Senate Bill 851 was Senator Perry's bill. He filed a bill on this the previous session as well that was a loser pays bill. Either side could get their attorney's fees, although he changed it from mandatory to permissive this session. And I think most of the folks at the legislature are real tired of hearing this issue, but I don't think that'll keep folks from bringing it back.
Yeah. Good point. And then next up is the pair of service area bills that I've asked Greg to touch on.
These are the two diametrically opposed bills dealing with retail public utilities. When we go to permit groundwater for use by a municipal utility district or a freshwater supply district or a water supply corporation, we typically have to look at how much they have used historically or how much they're planning on using that year, instead of looking at the area that they cover. A lot of people want to start issuing permits based on an acre-foot per acre basis, and if you do that, obviously utility doesn't own a lot of land. They're not going to get a big enough permit to be able to continue to operate. House Bill 2122 by Representative Harris would require utilities to either buy those water rights or at least obtain permission from the landowners within their service area to continue to pump that amount of groundwater. House Bill 2249 by Lucio, and this is a repeat bill, this is the third session I think on this bill, would require GCDs that issue permits based on acre-foot per acre to issue that permit to the utility based on their service area, not on the land that they actually own. This is going to be a struggle that goes on for a very long time between should the utilities be forced to buy water rights from others, and if we force them to do that, do they have a valid takings claim against the districts that adopt those rules because of their investment-backed expectations? this is a tough fight, and I don't know that the legislature can solve it. If they don't, it's almost certainly going to end up in litigation.
Thank you. And then I just want to mention, and threw me off when I didn't have my PowerPoint to start, but I do have these slides color-coded. So the items that are in red are bills that TAG's official position was in opposition to. The gray is the ones we were neutral on, and green is bills that we voted to support. I'm not going to go back in the slides, but on the bills that passed, those bills were all either green or gray. Just in terms of, how did things go from TAG's perspective in the legislative committee? Wanted to throw that out there. So now, back on track. Brian, sorry to eat into your sentence. I just asked you to touch on House Bill 726, the omnibus legislation from Larson this session.
Yep, 726, omnibus bill. We've seen it filed again. It was a little different this session because some parts of it passed in separate legislation last session. But basically, it ended districts' ability going forward to issue separate permits for an export of groundwater out of the district. It places limitations on districts putting a moratorium on the issuance of permits generally. It had a few other little things like in considering whether to grant or deny a permit, allowing districts to consider the impacts on exempt wells. And it had a provision that said a permit applicant is entitled to have his or her permit application processed under the rules that were in place at the time that application was filed and administratively complete. It didn't pass. I do think you will see most, if not all, of that bill come back again next session. I don't know if in one bill or multiple bills, but I think you'll see it come back.
Yep. And then the last one on this list, I asked Ty to mention House Bill 4570.
Right. This is a Chairman Larson bill, and it's something that the House Natural Resources held hearings on last interim, and it deals with the interaction between surface water and rivers and groundwater and aquifers. And I can just check off on the top of my head multiple Devil's River, Menard, Bastrop County. There's places where wells are close to the rivers and lakes, and it's like, are they hitting aquifers or are they hitting underflow of the surface water? So I applaud Chairman Larson and his leadership to try to address this issue, because it's a tricky one. You got the TCEQ involved, you got groundwater districts involved. It needs a lot more science, a lot of more investment in that, but that's something we're going to be dealing with as we go forward. And so this would have created a surface water and groundwater interaction advisory board to study the issue and come up with recommendations on how to deal with the regulation of water that, right, it's ground, you don't know if it's groundwater or surface water, those kind of issues. So hopefully Chairman Larson will continue that effort, and we can continue to work on it.
Thank you. And then when I was making this slide, I thought about trying to Photoshop their faces into that of a fortune teller, but I'm not that good at Photoshop, so so I didn't do that. But now I do want to look forward and ask these gentlemen to share with us, and they've already, I think you've all touched on it at least once in your comments about, what we might see over the interim in terms of, specific topics, policy discussions in groundwater. And since you have the microphone, Ty, why don't we start with you?
Yeah, to talk big picture, like this session, as Greg said, public school finance was a big ticket item, and property tax reform was a big ticket item. It's clear with the census occurring in 2020, then that's going to be a redistricting session in 2021. So that's just every time they meet, and after the census, they spend a significant amount of time working on redistricting. And with the growth in population in Texas, it's going to be pretty crazy process. So that's going to soak up a lot of time. They're going to probably spend a lot of late nights based on past experience working on that issue. I think from what I've understood in the interim, just kind of bouncing around, I think the leadership is putting a lot of emphasis in the interim on monitoring the implementation of legislation. I think there's a little bit of, I don't want to say frustration, but yeah, in the past they felt like committees didn't really follow up with, the state agencies and the rulemaking on bills that the legislature passed and make sure that the legislative intent was carried out. And so I think you're going to see that a whole lot more emphasis put on that this interim, as far as watching and following how the TCEQ, Water Development Board, Railroad Commission all put rules in place to implement the bills the legislature passed this past regular session.
Interesting. Go down to Brian.
I salute what Ty said. First of all, I think that's spot on. A little more focus on what did we just pass and how's it going to get off the ground and implementation mode. I think you'll see a little bit of apathy towards some of the things that we've been seeing year in and year out, service area battles. I mean, I think they're just worn out from that, like many of us are. I think you'll see a continued interest in the produced water from oil and gas operations. I think that's really starting to, both as a potential water supply and let's not impact oil and gas operations who need something to do with this water and it could be beneficially used. I think you're going to see there's a whole lot of legislation last session on that topic. I think we'll continue to see that. I think you'll still see an emphasis on water markets. I'm not sure that this interim they'll figure out what to do with that term any more than previous legislatures have, but I think it's still a buzzword they're going to pay attention to.
Greg?
In terms of specific issues, Brian's already mentioned oil and gas use recycling of their water. The similar rules bill that we talked about I know is going to come up. The de novo review I know is going to come up. I believe we're also going to see an interim study done on the DFC process overall. I hope that they talk about the useless, expensive waste of time called the DFC appeal process. But I think that probably we'll also be looking at questions about who should be serving on the GMA, who should have a vote, whether or not Regional Water Planning Group should be participating in the GMA process. I think all of that's going to be on the table, and they're going to be discussing that during the interim. And I think we're going to continue to see a fight between the concept of fair share and historic use for those that have investment-backed expectations and create potential takings liability for districts. And this idea that, the question was just asked a little while ago, do we protect the rural areas or do we allow landowners to sell as much water as they want to for use wherever it happens to go? So those issues are the big questions, the big issues. I'm not sure there's a solution out there, but I promise you they'll be talking about them.
And I'm going to have you keep the mic, Greg, and move on to our next question. And I think there's a nice segue there. I wanted to ask you all about what districts should be doing over the interim to engage in these discussions. And in particular, you mentioned this conversation about the joint planning process at the GMA level. Is that an opportunity? I mean, I'd love to hear from you not only on that topic, but just what GCD should be doing to engage and make sure that their voice is heard.
Well, absolutely. As you're going through joint planning, because our next DFCs have to be out by May of 2021 at the end of the next session, I think you need to make sure you keep engaged with your local legislators. If they're not aware of what you're doing or why you're doing it, when somebody comes in to complain about it, they're only going to hear that side of it. You need to make sure that they hear your side of it first. But I want to reiterate what I said earlier. It can't just be the groundwater conservation districts. Our job as a groundwater conservation district is to do what the legislature tells us we either have to do or we can do or what they want us to do. It's not our job to be telling legislators anything. However, the constituency, the people that we regulate, that community needs to be much more active in letting members know why they support the rules that they support and support their local groundwater conservation district. I think districts, when you look across the state, there is so little controversy, there's so little litigation, so few districts involved in any of that. Surely that means their constituency supports what they're doing. But as is usually the case, we only hear from people when they're complaining. So the legislators only hear from the complaining side. They don't hear from the people who are happy with what's happening, and they need to hear from the people who are happy with what their districts are doing and why they're doing it that way.
Thank you. You want to just...
Yeah, no, I mean, it sounds like a broken record, but I've said this before. All of us up here on the stage have said this before. You've got to get to know your legislators, your state representatives, your state senators, your county judges, your county commissioners, the city, the mayors, and the city councils. But at the legislature, there's just so much turnover. I mean, this summer's been amazing to watch how much staff and the announcement of people that aren't coming back to the legislature and the staff that's leaving to go on to new things. It's just a continual process to educate and keep them updated, and so you're not just showing up during session saying, help me in March of 2021. You've built that relationship. They understand your issues. And the other thing I want to say, and really to add on to what Greg is saying, because I couldn't agree more, I think a lot of times, in my experience, the legislators are, I hear from time to time, well, I'm out there trying to protect the small guy, the small landowner that the groundwater districts are, not treating fairly and not protecting their property rights. And I say, with all due respect, Mr. Representative, Mr. Senator, the groundwater districts are out there protecting everybody's property rights. They've got a job to protect everybody. And that's what they're trying to do. And so it's important to keep getting that message out there. And like Greg said, to get your constituents, get the people that you worked with, to get the district created, to get the rules in place. I feel a little bit, and I've talked to Greg and Brian about this, is that these people, there's this big effort community to get a groundwater district created. District gets up and running, starts has a good path forward, and then everybody forgets about it, and it's kind of like, okay, the district's good, we'll move on to the next hurdle. And so those are the type of people that helped us get the districts up and running, that we need them communicating with the legislators. So that's a crucial part of the equation. Thank you.
And Brian, please answer the first. Well, then that's great, because I was going to add on for you something that Ty mentioned. In terms of building these relationships, what specific steps should GCDs be taking? How should they be reaching out? How often should they be reaching out to legislative staff, legislators? If they've never done it before, should they be inviting them to board meetings? What action plan should we have?
From from a district perspective, it's a little easier. From our perspective, there's 181 legislative offices. When I chart out how I want to maintain good relationships with those offices so that when an issue comes up, I know some people there, I basically only, if I had a lunch with one of them every day, there's only opportunity for 2 a year, But for an individual district, know your state senator or your senators in a few instances, or your reps. Know who their district staff is. Know who their capital staff is, not just the chief of staff, but who is it that handles water issues. And as Ty said, those folks constantly turn over. But get in there and just go build a relationship like you would in any business setting. Want you to know what we're doing, because, again, you don't want the first time they encounter you to be this one upset constituent or permit applicant that didn't get what they wanted, or which is often the case in my experience. And if they say, oh yeah, courtesy copy them on your monthly newsletter that you send out. Send it to those legislative staff. A lot of folks have something that they send out on a regular basis, and they don't think to send it to their legislative offices. You don't have anything to hide. Let them know all the work that you're doing, because my experience is out of 181 of them, 175 of them don't have any clue how much work on different things groundwater districts do every month. And that's our fault. We could change that. Your fault. Sorry.
To end on a finger point, I don't know. So we do have a couple minutes for questions, and I wanted to first look to the audience. I've been trying to, I haven't been texting with my husband or anything here. I have been just watching to see if there were questions coming in, but I want to first open it up to the audience. If anyone wants to step up to the mic with a question. All right. So one did come in that I saw, and it had to do with the issue of concerns being elevated to the legislature before going to the district first by constituents, having folks complaining about problems that the district hasn't been aware of or that individual hasn't engaged at the district level. Is there truth in that? Is that what we're seeing? Is there anything we can do to combat it? You've got the mic, Brian. I'll maybe start with you.
I've seen that a gazillion times. It's as if the legislature is the appellate court for disgruntled groundwater constituents. And it's been that way since groundwater districts first became controversial, which happens to just be a couple of decades ago. There was many decades of peace and harmony. Yeah, I don't know how you deal with that. And the key thing to me on that is back to exactly what I just said. It's that you've already established a, you know, it's like with a relationship with the legislature. It's like when I hear about my kid who's the good kid doing something wrong, where you know that kid wouldn't do that. So that when you get somebody's tattling on you to a legislator, the legislator already says, that district's not crazy. That's not something they would do. Let's look into this a little further. I think you spell, because obviously there's nothing you can do to keep people from running to the legislature, and the worst part is you don't know about it. I could talk about having good constituent relations. That's a no-brainer, but they're still going to run to the legislature. So you have to have the legislature ready and knowledgeable about your operations when that happens.
That's a good point. Ty?
Yeah, no, I just couldn't agree more with what Brian said. But that's why it's also so important for districts to have good relationships with their county judges, their county commissioners, because if legislators, I got to find out about this district. If they don't already know you, they'll call their mayors, their county judges, and like, what's going on with this district? And if you have a good relationship with your county folks, your city folks, they'll go, oh no, the district's doing the right thing. They're doing that they're there to support you and set their record straight. So that's why it's so important to have a group of supporters outside of just the district and its board and its staff.
And to cultivate those relationships with those local elected officials. Exactly. Yeah. Greg?
I'm not sure what to add to that. Just if they already know you and they know your phone number, when they get that complaint, they're going to call you. If they don't know you and they're not that familiar with you, when they get that complaint, they're going to believe it.
Great. Well, I didn't see any other questions unless there's any from the audience. I'd like to thank our panelists. Please join me in giving them a round of applause.